live streaming. So thank you all for coming for our third installment of our Life Prep series. This one is Preparing for the Inevitable. And we have the attorney, David Peak, here to speak with us, to teach us, to guide us, and to show us the steps to make sure that, A, we're ready, but also that our families are ready for us. So thank you so much. I appreciate you.
Sure, glad to be here.
And welcome.
Thank you. All right. So with that introduction, I'll introduce myself a little more, okay? Just so you know who I am, my credentials and all that stuff. But let me start with what's in your packets. That was in the maroon folder. On the right-hand side is a copy of everything you're going to see up here, all right? It's little bitty PowerPoint slides, so it's kind of hard to read, so you might want to save it for later when you got better light at home that you can actually take a look, but feel free to make notes on there. On the left-hand pocket, you've got a few handouts. One is a list of the different types of estate planning documents that we typically do, estate planners do. The second thing that's in there is a family tree, a genealogical chart, because trying to figure out who you are in relationship to the deceased, okay? The next item that's in there is a printout of an article that is very interesting about your stuff, okay? Your junk. You said it, not me, okay? So it's written from a gentleman that had 2 or 3 storage units full of stuff, and just it's a very good article about what do you do with your stuff that in many cases nobody wants. So, okay, and that's the reality of it. And we'll talk more about that as we work through. And then the other thing is a little brochure that's just talks about the basics of estate planning, and we're going to go into a lot more detail this evening to talk about things that are part of life. Death is part of life, okay? So that's what we're here for. So this is me. I'm a local attorney here in Seminole, up across from the mall on Johnson Boulevard. So I've got a law degree from Stetson right down the road here. I've got a wife of 40 years. I've got 3 kids, 5 grandkids. I'm retired from the Army. I've been an attorney for 30 years, I think it is now. So I'm here for you guys. I'm going to go through my presentation. If you have any questions, I'm probably going to answer them while we're going through, but if you still have a question that you just got to ask, I'm going to stop and we're going to answer the questions. You got me today, this evening, for however long you need me, okay? So being a guy from the Army, after 30 years in the Army, I train to standard, which means I don't watch the clock and go, okay, I told Reverend Sandra that I was going to only take an hour. If we go longer than that, okay, we're going to keep going, as long as you can handle it. And if you need to leave, that's fine too, okay? Doesn't hurt me whatsoever. So what you're hearing in a lot more detail is what I talk with my clients about every day. I do estate planning. I don't do personal injury, criminal law, family law. I do wills, trust, and estates all day long, okay? So I kind of know what I'm talking about when I do this stuff, okay? Any attorneys in here before I get started? Not going to admit it. That's a good thing. All right. So let's get going. Here's the agenda of things we're going to go through. I'm not going to read the agenda to you because if you're like a lot of people, you don't like to be read to. Statistics. Got to kind of start with this to kind of give us a reference point for what's going to happen here, okay? Everybody dies, right? So are you prepared for that or are you not? And that's a really loaded question because you got to remember your estate plan is for the living, those that survive you. Yeah, it's your estate plan that goes into effect one time, typically. That's when you die. Powers of attorney are used during your lifetime, but for your will or your trust, you've got that in place and all the other planning factors for the living. So everything that you do as part of an estate plan is enabling the people that are going to take care of you or take care of your stuff when you're dead, all right? So statistically, 55% of adults die in the U.S. without a will. And that's okay, because some of them might have planned to die without a will intentionally, and we'll talk about that on how to avoid probate. You don't need a will, really, if you know how to avoid probate, and I can tell you how to do that. Life expectancy is right up there. Women still continue to outlive the guys, and I look in this room here, and I see one guy, not including myself, so there you go, you know. How many, I do have to ask this, how many of you are widows? Okay. Okay. So, I mean, that's most of my clients really are. You know, I don't see that many single widowers. I see married couples and probably more widows come in than I do single widowers, men. Here's our population. We continue to get older. Pinellas County still almost always historically, the percentage is about the same. About 25% of Pinellas County is over 65, and that is actually, the number has come down because more younger folks are moving into Pinellas County than 15, 20 years ago. It used to be the retirement spot, you know, and then everybody who retired in Pinellas, their parents had retired down in Fort Myers, you know, with the money. So the old people with lots of money are down in the Fort Myers area. Probate and trust cases, as you can see in Florida, almost 72,000 probate and trust cases in Florida. But once again, that doesn't really represent the number of people who are dying, because people do work around having a trust or probate required in order to pass their assets different ways. And in Pinellas County alone, almost 4,900 cases. So our court system here in Pinellas for probate and trust work, very, very busy. A common question, a lot of my slides are going to have a question that I'm going to answer. This is a common question that I get from folks: do I have an estate? Or they will say, I don't have an estate, do I? If you own anything, you have an estate. That would, if you die, your assets would be part of your estate. And that could be anything that you see listed there. If you own it and it's in your name when you pass away, it's part of your estate that has to be transferred to someone. So don't think you don't have an estate unless you absolutely own nothing, okay? So if you're over 18, you've got stuff. You probably own a car, checking accounts. Yeah, believe it or not, yeah, it has value, especially if, right, because it's paid for, prepaid plans, or even if you've done a prepay by purchasing an insurance policy to pay for the funeral arrangements, you could cash out that life insurance policy that is there to pay for your funeral arrangements. So, but a lot of these are listed on here according to Medicaid laws for qualifying for Medicaid. Those things are on the list of what is considered to be an asset as far as Medicaid would be concerned. And these are the same type of assets that whenever we're doing a probate administration, these are the things we're looking for that could potentially be part of your estate. And why do you need an estate plan? So that you're in control. When you pass away, you want to make sure that the right people get your stuff, okay, in the right percentages. You also need to make sure that you've got the right person selected to be in charge. That's your personal representative. Here in Florida, that's what we call an executor here in Florida, or a trustee if it's a trust. But your plan has to be in place prior to your death. Nobody can put an estate plan in place for you after you've passed away. So you got to have it done in writing, correct format. The format is very, very important when you do an estate plan. When should you have it? Obviously, before you die would be a good thing to do, and preferably before you're losing your marbles, okay? If you lose mental capacity, it's too late. Okay, there can be some planning done if you have a power of attorney in place prior to losing your mental capacity. Physical incapacity is not that big of a deal because as long as you can tell someone what you want, somebody can sign your will or your trust for you. That's perfectly legal. But you have to have capacity and you have to be alive. So that's your win. But if you own any assets, that's really the start date of when you should think about putting an estate plan in place. How often should you update it? That's another one I hear all the time. And typically the big picture answer is whenever something significant happens. And that could be the loss of a spouse, the loss of your beneficiaries, if it's your children that are listed as your beneficiaries. If you get a bunch of money that's going to be significant in your lifestyle change. Before traveling, I do that one a lot, especially with younger parents who have minor kids that are leaving the kids with grandma and grandpa. Often we do an estate plan to make sure that we can take care of those kids if something happens when they're on vacation. But the main reason is when there's a substantial change in the circumstances. Divorce, death are the big ones. So what is an estate plan? It's basically the plan for transferring the assets upon your passing. And then also an important part is having those powers of attorney in place to be able to manage the assets during your lifetime if you do become physically or mentally incapacitated. But it's a strategy. And in most cases, the plan passes the assets from one generation to the next generation, kind of like things are done in the hierarchy of things. You just go down one at a time. Sometimes we have to skip an entire generation. I do a lot of wills and trusts that skips over the kids intentionally in most cases. And I mean, you'd be really surprised the very high percentage of wills and trusts that I prepare that omit at least one child for different reasons. Sometimes it's because, like the prodigal son, they've already gotten their inheritance, okay, so they're not going to get a second one as well. Or they might be incarcerated, so they're being skipped. Or they haven't talked to their parents in decades, so they're off the island. It happens very often. That's a conversation I have every single week. Who needs an estate plan? Anyone who owns assets. If you've got something that is in your name alone that you own, if you want to make sure that it goes to who you want it to go to, you have to have an estate plan of some type in place. And famous folks die all the time without wills. There's a list of some very famous people, some extremely wealthy people who died without a will, with no plan. Or, like in the case of Princess Diana over there, she had a plan in place. She had a written will. It included a trust to take care of her two sons. But prior to her death, she made a separate writing that left funds to godchildren who were not listed in her trust. So litigation ensued because nobody could figure out which took priority. So even though she had a plan, she messed up her own plan by trying to do something on her own. But a lot of these people, Abraham Lincoln, an attorney, first president to die without a will. I think he's the last president to die without a will. But there he was, a practicing attorney for many, many years. Didn't even have a will. Howard Hughes, multi-billionaire, when he passed away, it took his personal representative executor like 25 years to finally figure out what his assets were, and then his estate was divided between 34 different distant relatives because he didn't have a plan in place. So you just look at those names. A lot of them were celebrities that never got around to it, didn't want to put anything in writing, so they died without a will. And then depending on which state they died in, those states gave them their will, basically. So the laws of the state kicked in and said, here's the process, and here's who gets it after the payment of taxes and creditors and everything else. So what happens if you die without an estate plan? Potentially, if you haven't done beneficiaries or have beneficiaries on your assets, then we have to go through the probate system, which is a judicially supervised process of taking your assets from your name, identifying who your lawful heirs at law are, and then getting it to them after the payment of all judgments and creditors and debts and anything else you have. So if you die without a will or a trust, the terminology is you died intestate, okay? If you die with a will, you've died testate. These are old Latin terms. So if you die without a will, the state of Florida is going to give you a will. It's going to say how your assets are divided and it'll identify who your legal heirs at law are. So the basic estate planning documents, and I'm going to cover all these that are here. The big three are underlined and in italics. They're the ones that are covered in that little brochure that's in your folder as well. But these are the main things that you really need to consider. Do you need a will? Yes, everybody needs a will, even if you have beneficiaries listed on your assets. Because it's going to name, most importantly, the second bullet there. It tells us who's going to be in charge of handling everything for you when you're no longer with us. So even if you have beneficiaries listed on all your bank accounts, insurance policies, annuities, 401ks, IRAs, you still need the will because it's going to say, this is my personal representative to handle my final affairs. Okay, so everybody needs a will. If you have minor children, and I don't think any of us in this room have minor children, then you can also include a nomination for the guardian of any minor children. That would go in your will, because if you die without a natural parent or a guardian, then a formal guardianship will have to be set up for any of the minor children. So what is a will? A piece of paper, a napkin, whatever it might be, in the most basic sense. A will, as long as it says, this is my will, it's in writing, it's signed and dated and witnessed by 2 witnesses. Those in Florida, those are the most basic requirements for a will. But don't do that. Don't go grab a napkin out of the back and start writing out your will, okay? Because it could be challenged. So you need to make sure it's done with the formalities. But it basically is going to take care of identifying your personal representative and saying who gets your stuff, okay? A will doesn't have to list all your stuff. It can say, like most wills do, all the rest, residue, and remainder to my wife, to my children, and that's fine, okay? That's a simple will. So what are the requirements for a will? Bunch of little tiny writing there, so I've kind of covered them. You got to be 18. You have to be of sound mind, at least on the day that you're signing it, okay? You could lose your marbles the day after. You could have lost your marbles the day before, but you have to have testamentary capacity when you've signed that will for it to be valid in case it's challenged. Has to be signed and dated, and 2 witnesses, preferably the witnesses are not related to you and are not the beneficiaries on the will. If they are, it's okay. It's just preferred if you think there would be any challenge to the will, that you get independent witnesses to witness it. In Florida, a will does not have to be notarized for it to be valid. It just has to have 2 witnesses signed at the same time that you sign it, the testator, okay, when you sign it. Minimally, it needs to also include the nomination of your personal representative to administer your estate, and then it needs to have some kind of wording that says who gets your stuff, okay, in some manner. And that's why, once again, we always encourage, don't try to do this yourself, because if you word it incorrectly, then you're deemed to have died intestate, because nobody can really figure out what it means, okay? If it's signed incorrectly, it's void, all right? That's usually when we see people go online and download wills of their own, or they try to make something up. You go down to the law library and find a book of wills, because there's thousands of them out there, and then people mess up in signing them. And if it's not signed correctly, it's void. It can't be used. So what is a trust? And that's another question that I get all the time. What's this trust thing versus the will thing? So a trust is a legal entity that you create. It's your trust. You're the grantor of your trust. And then during your lifetime, you put assets into the trust. So you can transfer your real estate, you can put bank accounts in there, whatever you'd like that you can legally own personally, your trust can also own legally. So the purpose for most people to have trust instead of just having a will is to avoid probate, okay? To avoid probate. But there's other ways to avoid probate, because when you've transferred your assets into that trust during your lifetime, when you die, it's your trust. You manage the assets during your lifetime as the trustee, but they don't belong to you. They belong to the trust. So when you die, probate's not required because you don't own the assets. They're already in your trust. And then your successor trustee takes over from you as the trustee and then distributes the assets that are in the trust already before you died. They distribute it according to the terms of your trust. So you avoid probate. It's done without any court involvement unless somebody argues. So it can be a very, very fast process of distributing assets when you die, okay? Because the assets are already in the trust, okay? There's different types of trust. Most people have heard of a living trust, and what that simply means is during your lifetime, you have funded it, and it's revocable as well, because then you can modify it as you need to throughout your lifetime. Some people never amend their trust. Some people regularly amend their trust, like every year. I see the clients come back in. It's like, okay, what are we doing now? And somebody made them mad. They're off. And then 2 years later, they're back. So it's back and forth, and that's okay. You can revoke it and amend it as often as you need to. Durable power of attorney. So we talked about a will, talked about a trust. Power of attorney. Those are used during your lifetime to appoint a person, and then alternates as well, to serve as your agent to take care of things on your behalf if you become unable or unwilling, or you just don't want to be bothered. Okay, so you can appoint someone to take charge of your stuff, and you just say, hey, you're my power of attorney, and I want you to go sell all my real estate, send me a check when you're done, I'm heading to the Bahamas. It's that easy, okay? In some cases, powers of attorney are used when you're traveling and you need to have something finished up. Business folks use them all the time to take care of things on behalf. In many cases, husbands and wives will have them, and I know like I said, I'm retired military. In many cases, I would get to our next location before my wife. I had her power of attorney. I would buy the house using her power of attorney to put the house in our name. So there's lots of different uses for those. There's different types of powers of attorney. Some of them are limited, which means it can only be used for a specific asset, like buying and selling real estate, or it's limited in time, and which means it expires after 1 year. Okay, then you can renew it. I had to put another one in place. The use of the word durable simply means that it does not expire until you expire. But otherwise, once you've put that power of attorney in place, it's good until you're no longer with us, or the people that you've named are no longer with us. So you do have to update those occasionally. Healthcare power of attorney. It's obvious what that one's for health and medical activities. So in a healthcare power of attorney, you're going to list your healthcare surrogates to make health and medical decisions for you, pick up your medical records, pick up your prescriptions, whatever's necessary as far as your health and medical activities, if you become unable to take care of those things for yourself. Yes, ma'am. Should the person that you appoint carry it with them? Not always. What I always tell folks is once we've signed and taken care of everything, I remind them to make sure whoever you've appointed, either give them a copy and let them know where you've put the original, or at least tell them that you've done it. That way, although with my mom, she died years ago, but she always had, and I'm a preacher's kid, Southern Baptist preacher's kid. Don't hold that against me. My sister's an Episcopal priest up in South Carolina. Okay, she went to the dark side. You know, she was an ordained Southern Baptist preacher, and then she married an Episcopal guy, and I think the bishop of the diocese she was in said, you know, if you want to go any place with us, you got to go back to seminary and become ordained with us. So she did. A few years ago, she went to Virginia Theological Seminary and converted, and does great. You know, done good stuff, so it's awesome. Get to see her on YouTube, you know, with all the stuff on, and it's like, oh my goodness, that's like crazy. But anyway, where was I going with that? Yeah, so what my mom would do, always did, so we lived in parsonages our entire life, every church we were at. So she always had this metal box. It was like this, 100 years old, and no idea where it came from. That's where she kept the stuff that we were never to look at unless something happened. It was always kept in the guest bathroom under the towels. We knew it was there, and we knew we were never supposed to touch it. My father was scared to death himself of my mom, even though she was about this big. He never touched it until she passed. So she passed, he took the box, found his spare car keys. She had Alzheimer's, so weird things were in this box. Savings bonds, life insurance policies, their wills, powers of attorney, everything was jam-packed in this box. But all of us knew if something happens to mom and dad, we knew where to go look. So we didn't need to carry that stuff around. We knew where it was, which is the important thing. So healthcare powers of attorney, very important to have. On both of these slides, I've mentioned changes in the law, okay? 2011, Florida legislature updated the power of attorney laws for financial matters. In 2015, they updated the healthcare power of attorney laws. So if you've got durable powers of attorney or healthcare documents that are dated prior to 2011 for financial, 2015 for healthcare, you need to have them updated because of the changes in the law, okay? It doesn't make your stuff void. It's just there's more stuff added in the law that you need to make sure that you can benefit from.
With the letting people know and knowing where stuff is, also have it someplace that will be accessible. We went through this with my father-in-law. He was in the hospital. My husband needed to find the power of attorney, which was in the safe deposit box that he couldn't access because he didn't have the power of attorney proof to show the bank because it was inside the box. So don't do that.
Yeah.
Keep at least a copy outside the safe deposit box.
Right, right. And something like that, that's not the purpose of a safe deposit box really anyway. I mean, that's where you hide the cash you're trying to hide from the IRS or whatever, okay? So don't put your legal documents in there. Even your deeds. You know, many times when I open a safe deposit box under a court order, either I find absolutely nothing, which is probably 90% of the time is an empty box, or I find stuff that really shouldn't be in there. Deeds to property, they're public record. You know, it's not like back in the old days when you had that deed and that represented ownership. Not anymore. And that's hasn't been true for probably 50 years where that deed represented true ownership, you know. So just if you have a safe deposit box, really take a look at what's in it and make sure you have a co-leaseor own it, okay, or a leasee. A co-leasee on there so that somebody can get in there without having to go through a lot of issues to get into it. And if it's needed on the weekend, then if you've got your powers of attorney and healthcare stuff in the box, nobody can get to it. So you don't need to put that stuff in a box. Mm-hmm. Right. Right. Yeah. When banks change owner, oh yeah, when they change ownership or change locations, like SunTrust down here on Seminole Boulevard, they closed that location, merged with BB&T, and became Truist. they had to close out and find the people that had all those boxes in that big, and it was a huge vault that they had down there at the old SunTrust. And there's a insane process for how they have to notify people, publication notices, then they, under like 3 bankers have to go in, open the boxes with a locksmith to drill them open if they can't get them. Then they have to secure everything. They have to inventory every single item to a paper clip that's just in the box. And then they have to, it goes to a central retention place. It has to sit there for like 5 years. Nobody ever claims it. Then it goes to the state of Florida. Yeah, safe deposit box are a total nightmare for folks, unless you've got a co-leasee and it's really got some good stuff in there you're trying to hide from somebody. Okay, but don't let the bank know you got cash in there, because they hate it when there's cash in a box. They say, "What are we here for? You know, why do you have $50,000 in the safe deposit box in a bank earning 0 interest?" But in many cases, they're trying to hide it. You know, it's unaccounted for cash money. Okay. Advanced directives or a living will, that's part of a healthcare power of attorney. It's your wishes on what you want to happen if you're in a situation where you're typically in a coma, okay? You're in a terminal condition or an end-stage condition. And by Florida law, that's when Florida's living will kicks in. You have to be those 3 prerequisites, and then no reasonable medical probability of recovery from those conditions. Under Florida law, your declaration then becomes that you do not want something artificial done to you that would delay the natural process of dying. You can still be given palliative care, painkillers, but just no feeding tubes, no vents, no intubation, anything that's going to artificially keep you alive. If any of y'all have been here for 30 years or more, you probably remember the Terry Schiavo case, made international headlines. That was right here, and that's what has resulted in our current living will laws, which haven't changed at all, pretty much since after that case law went into effect. But that's your right to die, okay? Okay, do not DNR. That's another one I get. People come to the office, say, "I want one of those DNR thingies." I can give you a DNR thingy. Only a medical professional in consultation with you or with your healthcare surrogate can give you a DNR thingy. And if you've ever seen one, it's printed on bright yellow paper. The color of the paper is called goldenrod. Any nurses in here? No? So you sign it, the doctor signs it, and it basically says, "Do not resuscitate." But you can't just go get one from your doctor because you want one. You have to be in the medical condition where you should not be resuscitated. It's either because of what you've got, that you're going to die anyway, so if you happen to code, okay, you all have agreed you're just going to die. Or in some of our, like my office is across the street from Freedom Square, and there's a lot of people that live in there that weigh about 85 pounds, and if some big bubba paramedic that weighs 450 pounds comes in and even does one compression, they've broken them in half. So in those cases, it would be more damage done by giving CPR, so that's why a lot of folks have a DNR. It's because it would kill them if they tried to resuscitate them.
I have living will.
Yep.
I have the DNR, but I've got to state what conditions.
Okay.
I'm not going to live.
Sure.
But I don't have yellow paper.
Your DNR, if it's official, if it's a real live issued from a doctor, it is on yellow paper. Yeah. Well, the living will, I print my powers of attorney on grayish paper, because I use different colors of paper for the different items that we prepare. But the DNR, they're on bright yellow paper, just so they stand out right. And they're going to tell you, and it's great advice, put those type of emergency things on your refrigerator. Paramedics and firemen are trained, if they go into a situation in a person's house, to go look on the refrigerator. And the DNR, when it's printed out, the bottom 3 inches of it, you can tear off and put it in your wallet, because it's a miniature version of the top part of the DNR, because once again, firemen, paramedics are trained if there's a car wreck, trying to figure out who's who. They're going to look in your purse. They're going to try to see if you've got a DNR, so then they don't do something that they shouldn't, resuscitate you if you've got a DNR, because they're required by law. Yeah. Yeah, otherwise they... Yeah, because otherwise it wouldn't be recognizable in quick, just it's a white piece of paper. Okay, so what else did we talk about here? Did I skip a slide? Nope. All right. So, assisted living facilities. That's another thing that's really important to kind of think about. And I don't do too much of that kind of elder care preparation, because so much of that is just so personal to someone. You know, what can they afford, where do they live, etc. But it is something to always be mindful of, and these are the three biggies that are associated with moving into some type of assisted living or long-term care. Cost, of course, for most folks, unless you had the foresight to get one of those really neat long-term care insurance policies. And if you bought one of those years ago, they were dirt cheap. Now, for what you would have paid back then, and years ago is like 10 years or earlier, for what you would have paid for an annual premium back then, that's your monthly premium now for the same coverage. So here's kind of the cost, and these are probably even a little low. And the cost, of course, is going to be based off of where you are. If you go to the Barrington, a little higher cost than if you go to Angel Care Assisted Living Facility down on 34th Street South, okay? So different levels of care, different skill level of the nursing staff. So the cost is almost always going to be based off of primarily what level of care you need. Are you independent and you're just hanging out there because it's a really neat social environment like Lake Seminole Square, or are you over in Freedom Square where you're in the nursing mental side of it, memory care? Then your cost is $10,000 a month versus in the independent living part of Freedom Square, which is $3,500 a month, okay? So something to think about. Another important thing is who's paying. Is it you? Are you self-paying? And that's okay, because sometimes that income that you've got coming in matches what you need to pay. So it's like, yeah, why not? I'll go live over at Freedom Square, and it's like being on a cruise. For the rest of your life. Medicaid and Medicare might be picking up part of the bill if you're on Medicaid, and that's another conversation that I won't have, okay, about qualifying for Medicaid, because that's very, very detailed and extensive process. Insurance, do you have the long-term care plan in place that picks up a large portion of your cost? And then there are other options that people look at, reverse mortgages. Then they move into the facility, move out of the house, but they borrowed the money against the house. And that's a good option for a lot of folks, especially these days where overinflated values of the real estate gives you some good equity in there. The location, also another important aspect when you're thinking about assisted living facility. Are you near family? Are you near a support structure that you might need? Are you near your doctor if you need some specialty care? Conveniences, Freedom Square, once again, not that I'm a salesman for Freedom Square, but they're right across from my office. And then right next to Freedom Square is what? Seminole City Center. Everything. Publix is there. The gym's there. So if you want to do your silver sneakers thing. So Freedom Square is a fantastic location. So that's why they've got all those towers there with lots of people. Are you near your church as well? I go to Seminole First Baptist Church. So if somebody's living over at Freedom Square, they can go to Miller's Ale House, come over to the church, or whichever order they want to go in. Usually it's probably go to Miller's after the church. Had enough of that preaching. And then, of course, the most important thing, can that facility meet your needs? And your needs might be diet. That's priority for you because you're, celiac disease or something that requires you to have a special diet and a menu that only a certain facility can provide for you? Is there lots of social activities? Is there a gym there? Is it located next to a golf course? So that location thing is it's really important as far as does it have the ability to meet your needs, or are they medical? Do they have enough of a skilled nursing staff 24/7 to take care of whatever might happen to you? Also, I recommend go visit them. There's companies out there that they do searches for you. They're your cruise director. They don't charge you for doing it either. They're paid for by the facilities. So if you're interested in doing that, there's professionals that will find the place based off of your requirements for you. They'll take you there. A lot of, like Freedom Square, once again, you can do a weekend there. Okay, go hang out, go eat in the dining room, and get a feel for what the rooms are like. So don't just get on the internet and try to figure it out. Go visit them. Some trends that have come up. Pretty much things have changed a lot post-COVID. Actually, during COVID and then post-COVID, a lot more scrutiny about the staff and their training. And because of a lot of that scrutiny and extra requirements, there's a lot of staff shortages as well. Those two things kind of go hand in hand. And then there is a bigger shift to home health care, and that it's kind of a good thing that came out of COVID is a lot of the industry and the insurance companies started shifting a lot more of their assets to home health care. Because if you really don't, you just need a vacation for a few hours, or if you're a healthcare provider, you're a spouse or you're taking care of somebody, it's good to have a day break or a 4-hour break. So a lot of these companies now will pay, Medicaid will do it, they'll allow for you to be given a break. And somebody comes in, sits with the loved one for a few hours, and you go to a movie or go bowling or go chase a little white ball around a golf course, whatever it might be. Pre-need guardianship is another important item for certain people, okay? So what a pre-need guardianship declaration is, it's a legal document that you designate in that document who would be your guardian if something were to happen to you and you were unable to express who you'd want to be in charge of your affairs. Have a lot of my clients where I'm designated in their files as their power of attorney, I'm their healthcare surrogate, and I'm their personal representative or trustee in their estate plan, because they don't have anybody else, or they're done with their family, and they're leaving everything to the SPCA, so they don't want their family involved. So for those folks, I put in place this pre-need guardianship declaration, which is filed with the court. So if those clients of mine go wandering off and are found on the side of the road, sheriff or the local law enforcement will check with the clerk of court and see if the declaration has been put on file. And then it's a lost and found thing, okay? They've already identified me, my phone number, my address. Sheriff's going to come find me if they find my client. So it's a good thing for memory care folks that start to wandering.
Is that in place of, or is that also, you have a power of attorney, is this something that you should have also?
Yes, you should have it also. And a lot of attorneys don't prepare them, just unless they really identify that, okay, you've got the spouse is taking care of another spouse, they're both in their early 90s, and then the husband has started to have a tendency to wander. If that comes up during the interview, it's like, let's put a pre-need declaration on file with the court, because then it's public record. The cops can find it, the probate judges can find it, whoever, I hate to say it, but the funeral homes can find it as well, because if somebody ends up dead on the side of the road, this is one way to figure out who should be contacted. So it doesn't replace the power of attorney. Power of attorney is really, that's a useful document to be able to take care of stuff. But this is an emergency notification system, okay? Final arrangements, another important thing to do, take care of those final arrangements, prepaid for your funeral, cremation, whatever it is, because you probably know what you would like to have done. You sit down with pastor and say, here's my plan for my service. I've already paid for everything, and then here's the songs we're going to sing, or whatever it is. You take care of it, and especially if you pay for it. That is such a huge burden to loved ones, to the survivors, if they know that all they have to do is pick up the phone and say, Mom died. And then Mon Funeral Home pulls in, and it's done. You've already picked out your casket, it's paid for, you've paid for the marker, whatever it might be. So if you can take care of those things, I encourage you to go ahead and make it easy. Because if you've ever done that before, been in a funeral director's office after someone has died, it's horrible. Emotions are high, and what happens when you're with a salesman when the emotions are high? You pay for stuff that you don't need. Hate to say that about funeral directors because I know a lot of them personally, but that's part of the industry, because they can sell you anything. They can sell you the little bitty urns for every grandchild that has a little bit of the ashes in it. You get the porcelain imported from, who knows where, instead of just the box, because you're going to be, the cremains are really going to go into a little tube out at Bay Pines for free. So why are you paying, $1,000 for a little piece of porcelain that you'll never see again? So. Right. Oh yeah, yeah. And keep in mind right, and if you've prepaid, you are also filling out your own death certificate. So that's another reason to take care of it, because in many cases, your kids or your grandkids, whoever might be taking care of things, they might not know the maiden name of your mother. That goes on your death certificate. They might not even know your father's full name. That goes on there. They may not know where you were born. So if you do all this stuff in advance, you've taken care of it and you've prepaid. So to do this probate thing, to claim any assets that have beneficiaries on it, you need a piece of paper called a death certificate. You only get death certificates from funeral directors that have been paid. Okay? They hold up everything until they have been paid. And that's for their protection. That's the way the laws are. So the printing of the death certificate is done by Vital Statistics, Department of Health. But all the information that goes on the death certificate is input by the funeral director based off of information that they're given. Do you have to have a funeral director? Yeah. And no matter what, a funeral director is involved with the process. Yes. Yep. You can't avoid them. You could, but then when your shark-eaten remains float out of the Gulf onto Madeira Beach, guess what? Sheriff's going to get called. They're going to call the medical examiner. Yeah. Just put lots of weights on your ankles when you jump. Okay? So here's your final arrangement stuff. Important to remember what benefits you might have available to you if you're a veteran or you were married to a veteran. There's some benefits that are available there. Social Security is also involved to give you that $250 surviving spouse benefit. I don't know what you're supposed to do with it, but go get it. But there's body donations. A lot of folks like to donate their bodies, but you have to do all that in advance, okay? A lot of us carry on our driver's license that says organ donor, but a lot of people like to take it to the next level to donate my body to science, okay? If you're doing that, it has to be prearranged, and you've got to make sure that you die in a facility that can keep you alive until they come and get you. Because in most cases, if you're dead for more than 24 hours, like if you're found in your bathroom and they don't know really when you die, they're not going to take you because you're of no use scientifically to them at that point. So they will keep you alive, just medically, keep you warm, okay? Your brain's dead, heart's still ticking a little bit to keep the fluids going through your body, and then they'll come pick you up and take you off to the University of Florida. Organ donation is a little different. But it's the full body donation that. Yeah, but mortuary schools don't really care. They'll take you in any situation, and if you've ever seen any of the funeral director shows that are on like Netflix or whatever, they'll take care of whatever to make you look like you're still alive. But the medical schools, they're typically going to want you fresh. Yeah. Kind of a fun discussion, isn't it? All right. Probate. What is probate? The Latin term that technically means to prove a will. Okay? So a probate is required for you because you have died owning assets in your name alone. That necessitates the probate process to get your assets that are in your name alone to someone that's alive or to an entity if you've donated everything to charity. So it's an important process because we need to make sure that your stuff gets to who it should legally go to, and especially if you have a will, we want to make sure that your will is honored. So that's why probate judges are around to supervise the process. Probate judges don't do the process just like any other circumstance in the legal world. If there's a problem, it's presented to a judge, the judge makes a decision. But judges sign orders in the probate system that makes things happen. So judges are a very important part of our probate process. So in Florida, we have 3 different primary ways of doing probate. Formal administration is the one that a lot of people are familiar with. That's where, if you're from some other state, you're more familiar with executor. So that term, so the executor is appointed, the executor is in charge. We call it a personal representative in Florida. So it requires the appointment by the judge of the personal representative. A key thing to remember is your will nominates your personal representative. A probate judge appoints legally the personal representative. So your will says, I want my brother to be my personal representative. That doesn't make him the, capital T, the personal representative. If necessary, the judge will appoint him and make him the, capital T, the personal representative of your estate. So it's real important in your will that you pick out somebody that is qualified, that could handle basically running the business of administering your estate. Because when you pass away and an estate is opened, it gets its own tax identification number, and it's a liquidation business. Think of it that way. An estate liquidates and transfers your assets to whoever they're supposed to go to. Okay? So that's a formal administration. You see the advertisements in the paper, notices to creditors saying, here, if you got a claim against the estate, here's who you contact. The next level of estate is a summary administration. It's a quick process, usually takes, here in Pinellas County, takes typically about 30 days, but you have to qualify to be able to use the summary procedure, which means the assets are $75,000 or less, which does not include your homestead residence if you have one. So you can live in $1 million place out on the beach, but then if you've got bank accounts that are $50,000, we can use the summary administration process for you, and it's a quick thing. It just kind of cleans things up. It used to be called a family administration. They changed it to summary. Some states call it a small estate. And depending on which state you're in California, a small estate is $350,000 or less. In Florida, it's $75,000. Alabama, $6,000 or less. So you don't see, that's hard to get within a $6,000 or less like they do in Alabama. The lowest level of administration of probate is called a disposition without administration. It's a paper drill, handwritten forms that are done. The clerk of court can kind of assist with doing those. They're typically used by assisted living facilities or nursing homes or the jail system. The sheriff uses them when someone has died and they've left this stuff in the room, and they don't know what to do with it. But to legally dispose of it, they go to the judge and they get an order that says you can legally dispose without a probate administration of these items, okay? We do, in my office, I probably do about 75 to 90 summary administrations a year. So if I can squeeze somebody into doing a summary administration, I do it because it's quick. It's a real quick process to open an estate, get it done, get the assets to the beneficiaries. Sometimes it doesn't work. The assets are more than $75,000, and I have no choice. Okay, so what does probate cost? That's another question I get all the time. If we're doing a formal estate administration, typically 4 to 8% is normal, and that's of the assets, of the inventory assets going through the process. Okay, so if you pass away and half of your assets have payable on death beneficiaries on them, POD, the other half doesn't, the cost involved with probate is only for the portion going through the probate process. So the costs and fees that are involved within that 4 to 8% are filing fees and court costs, which are fairly minimal. To open an estate here in Pinellas County, it's usually $375 to the clerk of court, so it's fairly cheap. The expensive part of it becomes paying me, okay? The attorney fees. So if you can avoid me when you die, you've saved your family a lot of money, okay? But like I said, I do 75 to 90, and that's me. I'm a solo practitioner. My little office, I'm doing 75 to 90 summary administrations every year typically, because that's how many people didn't plan, okay, correctly. And I probably do another 15 to 20 formal estate administrations, all right? So if you can avoid the probate stuff, then you're passing more assets to your family, to your church, whatever your beneficiaries might have been that are identified in your will. Okay, you've got to do, if there's real estate involved, you're probably looking at having the property appraised for your inventory. You know how much it costs, so you know how much to sell it. You've got to do final tax returns. So there's, once again, a probate administration is a business. It's a liquidation business, so you have to go through all those steps. A lot of professionals are involved with it. Repairs to the house. The list is endless, and it's unique to every probate estate when someone dies. So how do you avoid the previous slide? Okay. Put beneficiaries on your assets, payable on death, POD, or TOD, transfer on death is another term that's used. You want to avoid it because it can take a lot of time to do it, 6 to 12 months if we're doing a formal. It's costing money that would go to your beneficiaries otherwise, so if you can avoid it, just more money is transferred to your beneficiaries. And sometimes there's a hardship on the beneficiaries, and that one just really kills me when a surviving spouse comes in and for whatever reason, husband and wife didn't own everything jointly. And then the surviving spouse doesn't have access to the bank accounts. If it's a mixed marriage, it's a blended marriage with he's got kids, she doesn't have kids, they've been married for 40 years, he died without a will, the house is in his name, guess what? She gets 50%, his kids get the other 50%. That's by law, okay? But if there had been a will, he could have left everything to her. If he'd have had the house jointly owned between the two of them, wouldn't even be talking about probate, okay? So you kind of got to do the analysis of all your assets and say, who owns it? What happens if I die tomorrow? What would happen? I like to play that what-if game with my clients because then the lights go on and they kind of start shaking and, you know, they want to go to the bank real quick and put beneficiaries on their accounts once we've had the conversation. So probate avoidance, how do we do it? Payable on death, transfer on death on your accounts. Joint ownership between spouses, very important to do that. And I will warn you, don't go put your kids as joint owners on your assets. Very dangerous. And the reason is liability, okay? Y'all are probably pretty settled in your lifestyle. Your kids that are 25, 30, 35 years younger than you, my oldest son's 38, I wouldn't put him down with me on any of my assets because he's a helicopter pilot in the Army. He flies commercial aircraft. He drives 90 miles every single day, so I drive 3. So he is exposing himself to car wrecks, other things that might go on. So I would never want him on my assets other than as a beneficiary. So my wife and I, payable on death to our 3 kids. None of our kids are joint owners with us on anything, okay? So liability. If your kids are on your bank accounts, real estate, get them off, make them the beneficiary. The end result's the same. You pass away, it goes to them. And in many cases, sometimes people mess up with the joint ownership thing. Instead of putting joint with rights of survivorship, they'll put joint tenants or joint owners. And what that means, if one of the joint owners passes away, their half belongs to their estate. So that half would have to go through probate. And there might not be a will for the one who passed away. So the phrasing is very, very important. Joint with rights of survivorship. Or if you're married, if it says husband and wife, that automatically means survivorship without saying the word survivorship. Husband and wife is automatic to survivorship. So that's one way. POD, TOD, joint ownership, gifts and bill payments, okay? That's a great way to avoid probate, is to, during your lifetime, start giving your stuff away, okay? You can give up to, let's see where we're at, $19,000 in 2025 per year per person that you donate the money to. So go ahead and start giving the money to them now. If you don't need it, kids probably need it, so why not go ahead and gift it to them? You get to see how they are using it or not using it or abusing it, you know, wasting it, whatever. They're going to do it anyway when you die and they get it, so you might as well have a little guilt trip available when you're still alive and you give it to them, you know. But yeah, bill payments is another good way to take care of things. Pay a bill off, pay a mortgage off for your kid. Once again, you're avoiding probate because you don't have it when you pass away, okay? Yeah, I encourage people with that, especially with if you look at that little paper that's in your folders there about junk, okay, that nobody wants. Give it to them during your lifetime and torture them with it. So you give them the old china or silverware set, and you go, hey, on Thanksgiving, let's pull out the china and the silverware that I gave you last year. And their eyes will get this big, you know, trying, oh, what do we do with that stuff? You know, did they donate it to the thrift store or something? Okay. Avoiding probate with a living trust. Once again, you transfer the assets to your trust during your lifetime. It's not yours when you die because it's in the trust already. So those assets avoid probate. And you can also make the beneficiary, if you have a trust, your assets can be listed to show that the beneficiary is your trust, payable on death to your trust. That avoids probate because you had a beneficiary listed on it to your trust. That's okay. Life insurance proceeds, great way to pass wealth is through life insurance. Okay, but once again, if you don't need the life insurance, you know, you got to take. Why are you insured? Because what happens when we get older with insurance? It becomes more expensive. If you get above like 80, it's crazy. How much the monthly or annual premiums would be. And you got to remember, I'm kind of a Dave Ramsey financial kind of guy. Okay, I used to teach his Peace University class, and he'll tell you, don't get insurance if you don't need to carry insurance. It's a substitute for a lifestyle. So me and my wife, we carry $1 million policies on each other. Okay, as we get older, we don't need that anymore because everything's paid off. I won't be working anyway, hopefully, you know, at that point. So you're not really replacing income if you don't need to because it gets so expensive. I've got a 20-year term policy, so my premiums will never go up until I'm 82, 83, something like that. So you can get term policies very cheaply, but keep in mind who is the beneficiary of your policy, and does it make sense to have them as the beneficiary and to pay those premiums because they're not dependent on you. So why are you, spending $500 a month on insurance for somebody that's not dependent on you every month to month? Different when you're married. The life insurance, proceeds from retirement plans, 401ks, make sure you've got beneficiaries that are up to date on all those things. So estate planning team, a lot of folks can get involved with your plan. Everybody's unique as far as the team members. So I have 2 slides here of all the different people that could potentially be involved in your plan. Family's probably number 1 because they're the ones that are going to typically benefit from your plan. So you're either including them or you're excluding them. In that case, children, blood children, adopted children, stepchildren. They're all treated differently, and halves as well is included in that. They're all treated differently if you don't have an estate plan, if you don't have a will. There's a whole part of the law that covers if you die and you've got half children, you've got multiple kids from different marriages, different spouses were involved. It's a nightmare trying to figure out who gets which percentage. And then if there's a surviving spouse and then all these halves and stepkids, they're involved too. They get a different cut. But if you've got a will or trust in place, you've determined who the beneficiaries are and what cut they're going to get. Your friends and organizations, CPAs, financial planners, long-term care, your pastors are heavily involved with your estate plan, believe it or not. Because who's going to be there for you when it comes to the end? Your ministers are going to be there. They need to know what your final plans are. Your church is very important for leaving stuff for your church, okay? I'm a big believer in that the churches and the religious organization should be taken care of. That's our duty. The beneficiaries, guardian potentially, is also somebody that would be involved if you're under a guardianship for whatever reason, mental or physical incapacity. Powers of attorney, healthcare, surrogates, probate judges, and the one on the bottom, creditors, the other team, okay? They're the bad guys when you die, okay? So, how do you avoid creditors? Pay your bills, for one thing, if possible, okay? But if you avoid probate, you avoid creditors when you die, okay? Because if you die with no assets, which means it's not that you didn't have assets the day before you died, it's the day after you died, all your assets have beneficiaries on them, or they're in a trust. So they're paid on death to somebody else. So you don't have to go through the probate process. So in Florida, and probably every state, when creditors are out there, they're looking for an estate to be open, and then that's how they file their claims to get paid. There's a formal process in the statutes that tells creditors how to get money out of an estate. And the same portion of the probate code also says these assets are exempt from the claims of creditors. Your homestead, if you die survived by a spouse or children, your vehicle, up to 2, those are exempt from creditor claims. Up to $20,000 of your household goods are also exempt. What's not exempt that the creditors are looking for is bank accounts, insurance policies, whatever cash and accounts are having to go through probate. So once again, avoid probate, avoid the creditors. Okay? So that doesn't mean that the week before you die, because you know that you're terminal, that doesn't mean you go run up all your credit card bills and buy new TVs and furniture and all that stuff for everybody, and then you've got a $50,000 credit card bill, but then you don't have an estate because everything's payable on death to the same people that you bought the TVs for. I can tell you that because I've seen it. That does happen. People figure it out. Oh, wait a second. Go run up all the credit cards and they die with nothing. Okay? So avoid creditors. Avoid probate. Avoid creditors. And creditors know the deal too. Some common mistakes. Failing to do anything is really the big one. This conversation is difficult for a lot of folks, talking about end of life stuff. It's going to happen. It is going to happen. Unless the good Lord comes before you kick the bucket, you will die. It's not an F question, it's a win. So plan for it. Do something. Get beneficiaries on your accounts. You don't have to come see